Good day, everyone. Welcome to the Seattle University School of Law's third annual Supreme Court Rapid Response webinar. I'm Tony Verona, Dean at Seattle University School of Law. This year's Rapid Response webinar is on last Friday's Trump versus CASA decision addressing the constitutionality of nationwide federal district court injunctions in a case involving the issue of birthright citizenship. We are joined by many of the nation's top constitutional law and federal courts experts to examine the case and its ramifications in depth. I am delighted that the webinar is hosted by our new Seattle University School of Law project on the Supreme Court and our constitutional future, led brilliantly by my dear colleague, Professor Andrew Siegel, who will be speaking to us momentarily and will be leading us for the rest of the day. Professor Siegel's new project joins an array of cutting-edge programs and initiatives at Seattle University School of Law that make us one of the top 20 most innovative law schools in the nation, according to National Jurist, with top programs in areas including constitutional law, civil rights and critical justice, law and technology, international law, experiential education, legal writing, criminal and family law, with one of the richest curricula in the nation taught by a faculty repeatedly recognized as #1 in the entire Pacific Northwest for its scholarly influence. Our law school is proud to sponsor this third annual Supreme Court Rapid Response webinar. We thank our illustrious speakers and all of the staff colleagues responsible for a successful day. Thank you all. And now, without further delay, I will turn things over to Professor Siegel. Thank you.
Thank you, Dean Verona. Welcome to everyone for this third annual webinar. We've had exciting panels the last 2 times, and we've got many of the great panelists back, along with a bunch of new guests. We're thrilled at the experts we've been able to bring in. I'm going to do the shortest of introductions of the cases, and then we're going to have 2 full panels, the first of which is going to be moderated by my colleague, Erin Carr, and the second one I'll be moderating myself. So the case, as you all know, is Trump versus CASA, the case that involves both the Trump administration's determination and executive order attempting to curtail birthright citizenship, and then more directly, the question of the viability, the legitimacy of nationwide injunctions from district courts against potentially illegal or unconstitutional government actions. To get people up to speed who may not be lawyers, maybe hearing about these issues in detail for the first time, just really a couple of sentences. First, on the 14th Amendment. The 14th Amendment, in its first guarantees citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof. Supreme Court cases from the 19th century, the strong weight of commentary, really the assumption of scholars and lawyers for generations has been that those exceptions are narrow and that birthright citizenship is a firm principle available to just about everyone who is born in the United States. The Trump administration has challenged that with a bold executive order that claims the authority to redefine birthright citizenship and claims the authority in favor of a narrower understanding of birthright citizenship that is counter to what was, up until moments ago, pretty much a cross-ideological consensus. That policy has been constrained, enjoined by several district courts in litigation filed immediately. The Trump administration made the strategic choice not to challenge those injunctions on the merits in the Supreme Court, but to ask the Supreme Court for the slightly lesser relief of reviewing the case and determining that the injunctions in those cases should only apply to the parties, that the nationwide injunctions entered by the district court are impermissible, are in excess of the authorities of the district courts. This is an issue that has been brewing in a variety of disputes for about 2 decades now. Lots of scholarship on it. We'll hear about it. But the court has rejected attempts to hear this issue and decide it in many other contexts. I made the somewhat curious to many decision to do so in this particular case. And I'm sure panelists will speculate about the why and the meaning of that. The Supreme Court's decision, in one sentence, is that the Judiciary Act of 1789 that gave the courts its power did not give district courts, trial courts, the power to enter these kinds of injunctions for reasons related to the history of equity jurisprudence in England at the time of the founding. We have two panels coming up. The first is going to focus on the issue that I just ended with. They're going to focus on the decision about the illegitimacy of national injunctions, the ramifications for that, for civil rights litigation, for constraining executive power, and the rule of law. The second panel is then going to look more specifically at the birthright citizenship issue, talk about where the case is heading with regards to that, talk about ramifications, if any, of this decision on those issues, and talk in general about what is going on in the Supreme Court with regards to some of the aggressive and likely unconstitutional decisions and actions of the Trump administration. So I'm thrilled that all the folks here could make it, all the panelists. I respect each and every one of them. They'll get brief introductions when they speak, but mostly we're going to try to use the time to hear their expertise. So without further ado, I call on my wonderful colleague, Erin Carr, to get the first panel going.
Thank you, Dean Verona and Professor Siegel, for introducing today's event and framing our discussion around the Supreme Court's recent decision in Trump v. CASA. We are so fortunate to have with us today an exceptional panel of legal scholars consisting of experts from across the country. I will begin by briefly introducing the discussants for our first panel, while recognizing that the time constraints simply make it impossible for me to do service to the full depth and breadth of knowledge represented on this panel. And then following introductions, each discussant will have approximately 7 to 8 minutes to share their legal analysis and observations regarding the significance of this decision, drawing on their individual areas of expertise. And then time permitting, we also hope that we may be able to address some audience comments and questions. So joining us from Boston University is Professor Portia Pedro. Professor Pedro studies the ways in which racial subordination and subordination of other marginalized groups are embedded in civil procedure, remedies, and federal courts. Of particular importance to today's conversation, Professor Pedro is the author of The Myth of the Nationwide Injunction, published in the Ohio State Law Journal. We are also fortunate to have with us Professor Darren Hutchinson, who's the Emory University School of Law inaugural John Lewis Chair for Civil Rights and Social Justice, where he also serves as the faculty director of the Emory University Center for Civil Rights and Social Justice. Professor Caprice Roberts has also generously agreed with us today. She holds the position of the J.Y. Sanders Professorship, the G. Frank and Wilson Purvis Professorship, and also serves as the Associate Dean for Faculty Development and Research at Louisiana State University. Her scholarship and teaching are focused on the proper role of the judiciary and the advancement of the law of remedies. She's considered to be one of the premier remedies scholars in the nation, having most recently completed a new edition of the treatise Dobbs and Roberts' Law of Remedies, and published the 9th edition of a leading remedies book, as well as a co-authored casebook on federal courts. Next, we have Professor Leah Littman, Professor of Law at the University of Michigan, where she teaches and writes on constitutional law, federal courts, and post-conviction review. Her research examines the unidentified and implicit values that are used to structure the legal system, the federal courts, and the legal profession. Professor Littman also co-hosts the wildly popular podcast Strict Scrutiny and is the author of the book Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, published just last month. We are also pleased to welcome Professor Ilya Somin, Professor of Law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. And then lastly, we have Professor Holly Brewer, the Burke Professor of American History and an Associate Professor at the University of Maryland. She is a specialist in early American history. So because there is a great deal to discuss and we have very limited time, I would like to begin by inviting Professor Pedro to begin our conversation.
Thank you. A lot to say on this. One thing is that I'm going to be calling these injunctions impact injunctions for reasons I talk about in this as of yet unpublished article. And so we're talking about court orders that require defendants engaged in illegal or unconstitutional action against an extremely broad swath of people, potentially limitless, or entities, to stop engaging in those specified illegal or unconstitutional actions, period. You can say against anyone, but it's to stop engaging in those actions that are that a court holds unconstitutional or illegal. And so I call them impact injunctions. I think this is involving impact litigation and facial challenges in ways that we have not fully discussed yet. Now, whether federal courts have the jurisdictional and prudential power to issue impact injunctions has been the question until now, right? So can federal courts issue these injunctions? And even if they can, should they? So I think the court answers incorrectly as to both of those questions, and we'll talk some about my reasoning on that. So the majority has said that injunctions can be no broader than to provide complete relief to plaintiffs withstanding to sue. That's not so different from some of the things that have been said before. But another part of what they say is that impact injunctions, they say universal, exceed federal courts Article 3 equitable authority under the Judiciary Act. Here is where I have more than a quibble with them. Something to note, however, here that I'm sure people will also talk about later is that for the specific injunctions at issue in this case, the court says that they likely exceed federal court's authority. Why did they say that? Because there's a question that the Supreme Court is not supposed to be answering, right? These are in the hands of the district courts regarding what is complete relief for each plaintiff. District courts are supposed to be deciding relief and who has standing to sue. And that's noted in a concurrence. There's a question about state plaintiffs and what complete relief to state plaintiffs would be. So this idea of complete relief and what it means, and if injunctions doing some of what I've mentioned in terms of requiring defendants engaged in wholly illegal or unconstitutional action to stop engaging in that action, there's still some questions left there. So the most notable thing I think of with this case and with the majority opinion is what is not mentioned from the beginning. What is not mentioned from the beginning is what the standard is that applies to the question that they're actually addressing. I think a big thing with that is we start with the government is likely to succeed on the merits of its argument regarding the scope of relief. But then we have in the quote from the Can Be Holder, what is that first part of what the court is supposed to be considering in deciding whether or not to grant a stay? The applicant must make a strong showing that it's likely to succeed on the merits. It doesn't say on the merits of the little pretend issue that they've carved out to try to just get this handled when they know they're going to lose on everything else, right? It's supposed to be in general. So I think there's a larger question in the framing of the case and in what is actually being asked. And I do understand that the federal government, of course, with purpose, did not challenge the rest of the injunction, right? They only asked for a stay for the specific component of the injunction that was beyond that which they said directly applied to the plaintiffs. But there's not another circumstance under which federal courts, including a district court, or the Supreme Court are completely curtailed by what a defendant has asked for, right? That's what they want the issue to be. That's what they framed the issue to be. In deciding whether or not to let the stay stand or to instruct district courts to constrain the stays, the question has to involve, in my opinion, the entire merits, not just the merits of this argument regarding the scope of relief. So that's one thing I think to kick us off, is that you don't want to miss what I think is actually going on here by only talking about injunctions and the questions there. Now, when we go in to looking at whether federal courts have the authority to issue impact injunctions, the types of injunctions we're talking about, you're looking at Article 3 and case or controversy requirement, right? And what you have here is that the majority says that it has to be looking for an analog that was in the High Court of Chancery in England. We're looking around 1789. Now, what I'll say is that's a limit that's imposed to only seeing those analogies and to missing the analogies that actually make sense with what we can see in our system. So one thing is, when we're looking for this, we should look not just in the England's High Court of Chancery, because as Professor Jim Fander and as Jacob Wenzel have put forth in articles, we have the Article 3 judicial power is equitable and common law. So you look before the High Court of Chancery in England, even if we're going back to England in 1789, there's the Court of the King's Bench. That was the entity actually issuing the analogous relief at the time. It did exist. What you were looking at there was administrative writs. They had at least 3 administrative writs that seemed very similar. What did they do? Those writs were for the judicial control of unlawful executive action. They were individuals seeking correction of public wrongs on behalf of the public at large. And in those situations, they could even be sought by parties extrinsic to the administrative action in question. So they went even further than we need to in the analogies here. So it seems pretty clear that there are analogs that the court is just ignoring. Even if that doesn't count, then what we are talking about the Judiciary Act, we're talking about 1789. And there's a lawful change that happened there in federal courts, shifting from common law administrative writs to equitable remedies, because the courts found that the common law administrative writs were inadequate. So we still have analogs in the US of what was happening in US courts. There are also 1890s cases that Professor Mila Sahoni has written about, Reagan and Smith, that make it very clear that is what we're looking at. I think going on from that, I'll say that a number of the cases that they point to, Frothingham v. Mellon, Califano, they all don't include this issue or address it at all. And what is there is supportive. So the last thing I'll say is that the Califano complete relief, that it can be no burdensome than necessary, no burdensome to the defendant than necessary. The governmental defendant proposed that self-serving principle in that case, and the Supreme Court in Califano declined to adopt that principle. So people keep citing that case for that principle. That principle doesn't come from the case, it comes from governmental defendants and was rejected in that case. You could say that it's brought up now. So I'll save the rest for discussion, but I have a lot to say on this, and I'm really looking forward to what others have to say as well.
Thank you for Professor Pedro. Next, I'd like to turn the floor over to Professor Hutchinson. You have studied extensively how social justice and civil rights are both advanced and obstructed under the law, examining this perennial theme from a historical lens, but also within the specific context of the Roberts Court. What is your broad reading of the court's decision in Trump v. CASA, and what might it portend for civil rights litigation moving forward?
All right, well, thank you for that question. I'm a law and society type person, so I can come in here and talk about doctrine, but I also want to talk about the impact on this case for our democracy and political system. But I'm actually going to start with the doctrinal issue, and Portia gave me a great setup by discussing the historical point that there are historical analogs to follow. But I actually want to take a slightly different viewpoint that history should not be the only thing that dictates the outcome in this case. And a lot of it has to do with the second founding, I think, in the United States. That is the creation of the 13th, 14th, and 15th Amendments, and then others like the 19th, where we get a constitutionalization of rights, national rights for all persons. All right, so prior to that time, even if we go back into the English system, those types of rights were very limited. In our own Constitution, the rights that they didn't exist in the original document, just a few, but they came with the Bill of Rights, which were added afterwards. And even those, according to the court, only applied to federal governmental action, not state action. So at that time, states were seen as the guardians of rights, and rights were protected in the states on a state-by-state, case-by-case type of basis. So it's not a surprise that you didn't see the nationwide, now called universal injunctions, sort of proliferating litigation at the time. We have a different right structure today. We have a different litigation structure. And all of this results because the country has changed substantially since that time. So if you're looking at this issue, yes, starting with history, I think, can be informative. But as Justice Sotomayor said in her dissent, equity itself is very flexible. It's evolutionary. And also, I think that our right structure, which is something I want to continue to emphasize, is very different than it was in early U.S. history. And that needs to be taken into account when we think about potential remedies. Another thing I want to focus on is this question of not even dealing with the overall merits, whether or not the executive order is permissible. It's shocking to read the case and they're talking about likelihood of success on the merits of whether or not the injunction was proper itself. The analysis, I think, would shift, or you could at least see it in a different light if the question were not that, but whether or not the injunction, whether or not the order itself is constitutional. So in other words, is an injunction, a nationwide injunction on a patently unconstitutional executive order, is this injunction overly broad? Now, the court can reach the same decision, but I think there's a lot of maneuvering that needs to happen before you can get to that point. And I think the dissent was trying to bring that out as well, not exactly in the same terms, but the president was asking to violate the law, right? So let me violate the law, not in these states because these people have sued, but at least in these other states. I shouldn't be bound by the injunction there. But if the order itself is patently unconstitutional, then I think there's an argument on the other side for the president. It's kind of like coming into equity with unclean hands. I know I'm violating the law, but the injunction is overly broad. One of those equity maxims that has existed throughout history is that the parties have to come with clean hands, and I don't see that happening with Trump, and that's not even an analysis that the majority went through. One other piece in terms of the law, especially remedies law, is to think about the type of defendant in this case. There is one president, right? There is one president. We're not binding 50 states. It's one president, one executive order decreed by that one president. And so the order itself is the same across the country. The governmental figure who issued it is the same across the country. I think that raises very different perspectives when we're talking about a rule that may bind 50 states or all of the branches of the federal government. This is literally an order against an executive order that was issued from one person, the President of the United States. And in remedies law, that part of that analysis is often used to determine whether or not nationwide injunctions are proper. If the policy is going to determine how governmental agents are behaving across the nation and it's illegal, then that seems to be something that would weigh in favor of the injunction. All right, so those are the broad pieces in terms of doctrine. There's just one thing what I want to mention in terms of the bigger societal issue. I think this is a cabining of remedies. All right, it's a cabining of remedies that has been happening for decades with the Rehnquist Court and with the Roberts Court. Here it's being done by cabining equity, which itself is a flexible remedy. So it's like counterintuitive to place boundaries, harsh boundaries, maybe unreasonable boundaries around something that's a flexible remedy. And the place you're going to get the most injunctions that have nationwide implications is in the public law litigation. All right, so parties challenging broad policies, the constitutionality of them, or whether or not they violate a federal statute, and the harms will be the same across the country, and there's a single source for it. The court, by cabining the equitable approach here, the traditional one, is cabining remedies, or at least forcing litigants to go through a number of hurdles in order to get that remedy. That is the class action. But as Alito points out in his concurrence, class action procedures are not the only thing at stake. It's also standing. So Alito teases an area where the court could actually apply procedural rules, again, to the detriment of remedies by taking a very harsh enforcement rather than a lax enforcement, which you said, of standing rules and also rules governing class actions. I also think this is cabining of remedial function of statutes and constitutional provisions. All right, so in a number of cases where involving federal statutes or constitutional provisions, historically, if the provisions were enacted to serve a remedial function, like the 14th Amendment, their terms should be construed broadly, and so should the remedies for them. All right, we have the opposite going on here. We have the 14th Amendment, which is definitely a remedial constitutional provision. Remedying what? It reverses the Supreme Court, right? The Supreme Court's declaration in Dred Scott v. Sanford that Blacks were not citizens of the United States, whether or not they were enslaved or nominally free. All right, so the 14th Amendment reverses that. Now we have the Supreme Court, again, siding with more powerful classes, ignoring this remedial function of the very amendment that reversed the Supreme Court by refusing to sustain what historically has been an appropriate remedy to issue in order to vindicate the rights of people affected by a patently unconstitutional executive order. So those are the broad points that I wanted to make regarding the impact on society, civil rights enforcement, and also the doctrinal questions. I will say one thing just to leave you with, and I've been thinking about this a lot with the Trump administration. There's a way in which in equity, if a party is a repeat offender committing violations over and over again, then that party loses sort of a presumption of good faith. Right? We see that a lot. So if you're coming back to court and you're making these arguments again, in equity, the court can say, well, we've gone through this with you before, etc. And in some instances, in equity, you can put the defendant in receivership, issue a structural injunction, supervision. There's a lot of stuff that happens. I'm not saying we do that with the Trump administration, but it's interesting that the court treats Trump as coming with a clean slate every time there's something litigated. All right, and so there's a presumption of good faith, even though, which means there's no contempt. We haven't seen that where it's obviously possible, and there's no piecing together of what's happening, kind of in the way that Justice Jackson tries to do in her dissent. What I mean by piecing together is this is a very comprehensive attack on rights by the Trump administration. So on some level, I think it is appropriate to consider whether this is just another effort to get around the Constitution. All right, something the court didn't want to do by cabining the scope of the framing of the issue, and also by cabining the type of remedies that could be issued by the courts. All right, so I think that that's a looming issue. The more and more we see unconstitutional practices where the lower courts are finding them unconstitutional, the Supreme Court kind of sort of finding them unconstitutional as well, or just skipping the issue altogether. The more and more we see these violations, at some point, I think there's a good question to entertain as to whether prior bad acts by the president should come into play, again, because it's just one president. You have the same entity engaging in wrongful conduct over and over and over again. And there I'm going to stop, and I can take any questions about what I've said in the Q&A. Thank you so much.
Thank you, Professor Hutchinson. Professor Roberts, I'd like to now invite you into the conversation, and perhaps we can build on Professor Hutchinson's observation that this decision is part of a broader trend of cabineting of remedies. What legal remedies may be available moving forward to states and individual challengers of potentially illegal or unconstitutional government conduct in light of this most recent ruling?
Sure, absolutely. I'll do my best to address that. And thank you so much to the Dean and Andy Siegel and Aaron. I was going to end on a similar point that Darren did about the assumption of good faith of all the actors and branch actors as well, that is an important part of the equation. In terms of remedies, we've been on this narrowing trend for quite some time, not consistently. So I'll talk a little bit about that because the U.S. Supreme Court has taken a renewed interest in equity and flexed its equitable muscles in many cases, in some ways that were controversial. So I think that's interesting how that will sit. But I think that this opinion is not a surprise at this time from this court and from Justice Amy Coney Barrett in particular. Not a surprise that she got signed this opinion. And I think the way that she wrote it, the citations that she makes, she's doing a careful dismantling, and it's in line with Justice Thomas and what he's done about going back to the founding on jury trial rights and looking at that. Of course, those cases on remedies cite to and rely upon the Seventh Amendment, which already has within it language that you talk about preservation, usually in most states, as well as the federal constitution. But at any rate, it's interesting to see. And I think it's because the majority is trying to address what they perceive to be an abuse of some, not just district court judges, but parties, perhaps themselves. Of course, this abuse, which you'd mentioned, is not unique to this particular moment. It is a recent history notion where we've been seeing this rise of nationwide or universal injunctions, but certainly in the Bush administration, in Obama, and Presidents Biden, and then the Trump first administration, and now the second, we're seeing the rise and the race to courts, all of those problems, which I think to some extent, at least the Justice Sotomayor dissent acknowledges. And I think that is why we're seeing more congressional hearings and some professors who have been more open to the idea that we should have some types of limiting principles. I think for me, the biggest difficulty I have with the opinion is that the framing, that once you ask the question of going back to the founding era, looking for an analog, the issue becomes that framing of what is the analog. And I think Portia nicely addressed that. And there are competing arguments on it. And to some extent, the majority opinion acknowledges that, talks about Mila Sahoni's article with some of those cases, but then in the end says, even if we have different histories about when this exact type of relief started, the majority says it doesn't go all the way back to the founding. But again, a lot of that is about how you frame it. What are we talking about? And I think for me, one of the difficulties is much of the opinion relies upon Grupo versus Mexicano, which itself is controversial to many remedies scholars. Many believe it to have been wrongly decided. But once you have it as the decision, there we are. So one thing I think about with this issue is I wish we had Justice Ruth Bader Ginsburg around, not necessarily because it would have changed the result, but it would have changed the conversation. I think her deep pedigree in litigation and civil procedure, her care for civil rights and remedies. And she did do a concurring in part and dissenting in part in Grupo. And in that opinion, she literally says, and remember, this was about the asset freeze injunction in Grupo and whether or not lower courts had the power to issue that type of relief. And the holding was similar. It was saying that under the Judiciary Act, that power was lacking. And in the dissenting part of the opinion, Justice Ginsburg says, I would not so disarm the district courts. And that's what we're seeing here, because we've made it into a power question exclusively, as opposed to a political issue that the other branches should deal with, or a prudential issue where we could talk about various equitable limiting principles. We've instead made it into a much more binary and therefore an all or nothing. But we're going to continue to see the all or nothing because we'll see the rise in the class actions already filed, right, on this particular set of cases. We're going to see efforts by Congress probably in response. We're going to see a lot of different things, but I think by completely taking away this in the arsenal from the district court and the courts of appeals, it could be very problematic for the narrowing of access to real relief for those that were proving to those district court judges, and there were several, all of them, I think, uniformly saying we find irreparable harm and we find likelihood of success on the merits for the plaintiffs here, talking about those who were seeking to show the unconstitutionality of the executive order. And I do agree with the comments that it's interesting when once you get to the stay up on the emergency docket, which of course there were sort of some movements right by Kavanaugh to sort of say we should have even more and more on that docket. And I think we'll see that. We're going to see more and more challenges coming on that docket. But what I think the court ends up doing is, in my mind, what I would call judicial jurisdiction stripping. Of course, the majority would respond to that and say, we're not stripping anything. We're announcing out loud what was never there all along, right? But I think it has certainly been there as a matter of acquiescence. The majority addresses that point and says, you know, it's not enough to just have a sort of silent acquiescence by the court, that we've got to go back to the founding and we have to find that analog. Then I do think reasonable minds and some of the scholars will bear out that there are some potential other analogs we could talk about. I am focused more on what Justice Ginsburg talked about in Grupo, which is the unnecessary calcification or sort of cementing of equity, which stands against the very notion and principles of equity. The idea of equity is to have some level of dynamism, of flexibility. That's the history of equity coming over from the chancellors. That said, I get it. At times we have things that might be unbounded. At times we have remedies that might go too far on that equitable level. And there are concerns about what they call the chancellor's foot or going without any limiting principles. But we don't live in those times anymore. We have precedent on the equity side. We have the ability to seek emergency relief. We have the ability to get on the SCOTUS docket on the merits. So all of that would have been subject to review and perhaps could have been handled in that way. And when we have had issues, and not all people agree with this, but when we had the Prison Litigation Reform Act, that was Congress saying, let's alter the standards for injunctive relief and make it harder. Now, again, civil rights lawyers are going to not love that, and they would like the California case of Miller versus French that the Ninth Circuit said that's unconstitutional, but the U.S. Supreme Court disagreed with that and said Congress can do that. Congress can make those limits. And those limits heightened what would be required. So if the court wanted to see this something approaching narrowly tailored or something where there's a deeper balancing than going back to the equitable traditional principles that now we've had announced by Justice Thomas in eBay, which are the sort of 4-factor test, the district courts did that. They followed those tests, they enunciated the reasoning, and we should be looking at whether or not that reasoning was an abuse of discretion, which, you know, I think Justice Sotomayor mentions that, and then Justice Jackson goes deeper in about, you know, criticizing the majority for getting into what she perceives as sort of minutia points, given the ultimate big ticket issue that's underlying all of this. And of course, that's the thing that makes the public crazy. Are judges acting in wild ways? And what about getting to the underlying real merits of this? And I know some people care deeply about the merits of the challenge. I'm sure we're going to hear about that. But I'm hoping that people pay attention to what I call the quiet corners of the law, those remedies issues. Like, this is purely a remedies holding, and it is going to have a wake that not only curtails and affects and narrows what's going on in these cases, Trump versus CASA and about birthright citizenship, but about all kinds of constitutional rights, all kinds of federal rights, even diversity cases that are up on appeal. It could potentially have a real sea change and narrowing. That said, maybe the Supreme Court is just leaving the work to itself. And I'm somebody who isn't without criticism for what some of the sort of national injunctions and how far they've been going, and the way they are perceived as well. I think there's some moments for judicial restraint there, some moments for limiting principles. But when we talk about now, we're going to leave it all to the Supreme Court for any type of clearing the decks or making a right secured nationally, even if there is an ongoing violation and it's patently unconstitutional. We're pulling right back onto Ex parte Young and all of those moments. And I agree, of course, with what Darren has said about we have to take notice of, if we are doing everything back to the founding, how do we reckon with the Civil Rights Amendments? How do we reckon with Ex parte Young? But maybe the court has something in mind for that as well, given that we've seen some narrowing of Bivens rights and remedies. We've seen some narrowing of habeas corpus rights and remedies. We've seen narrowing on standing in certain types of cases, but a broadening in others for corporations. The other thing I would mention, if I had another second, which I'll just say, is this is all part of an equity revival, which I have written about in broader contexts. And they're not all narrowing opinions. Again, the US Supreme Court itself has taken some cases and issued equitable remedies, including original jurisdiction in the case of Kansas versus Nebraska, which was a multi-million-dollar equitable disgorgement award by the court. It's taken a series of other cases that are about remedies, both equitable and at law, and the court seems to want to be in that function. And so apparently it wants to stay there because it's going to continue to be on these issues where we have rights that are only going to be enforced in some parts of the country and only to one person at a time. I thought the nuisance example does not hold up well in the majority opinion, where you have like each individual neighbor needs to go back and sue. So if we have a little girl at the doorsteps of the college, or a high school or a primary school or whatever, trying to get access into that building, and she brings it as one person in that lawsuit, are we saying that's it? Only, if we tell, and again, I think it matters that injunction here was prohibitory, telling the federal government to stop doing something that appears to be unconstitutional. And again, that was a preview of the merits, but the idea that you have to make everything into a class action at the same time that we've made it harder and harder for class actions to certify and to prevail is troubling, especially when you come back to the last point, which is we need to assume branch good faith when we think about the Youngstown and what sort of zone we're in. This is one actor or the executive branch acting alone in an executive order. We don't have Congress on board with that. We're going to see more and more of it because of the emboldening, and we're going to have very few ways to have courts do what they've traditionally done, which is exercise equitable discretionary powers to issue complete relief, to fashion relief as they see fit, and have that go up on appeal and be curtailed if it needs to be, or be dealt with in a congressional response if we want to have panels that deal with it instead of one judge, or rotating where we have a random draw for which judge it will be. I have lots more to say too, but I hope that more and more people will pay attention to remedies as an important part of, if you don't have a remedy, you may not be able to have that right that was so important. Thanks so much.
Thank you, Professor Roberts, for offering that helpful context and background on the remedies issue intrinsic to the opinion and explaining the far-reaching impacts of the decision. Our next discussant is Professor Littman, and we're curious to hear what your assessment is of Trump v. CASA, kind of including within the larger context of the many controversial opinions this term, and whether there is evidence of conservative grievance, fringe theories, or bad vibes embedded in this opinion that you were able to detect.
Thanks so much for the introduction. I'm so sorry for having to join late. I had another obligation, and so I'm especially apologetic if any of my remarks unthinkingly replicate what has already been said. So I had wanted to highlight a few big picture ideas that I see in Trump versus CASA. One is what I view as a pattern of the Supreme Court, and not just the Supreme Court, but the court in general and previous courts, narrowing the reach of the project of Reconstruction based on the idea that Reconstruction is a little too radical. And then the second is the context in which the Supreme Court opted to take up this issue, and I worry send a concerning signal that legitimizes the Trump administration's attacks on lower courts in particular. So I'll start with the second point, which is the Supreme Court's decision to take up this issue now and in this case. I'm sure it's already been noted that this issue of nationwide injunctions is something previous administrations have faced, and it's also something that previous administrations have asked the Supreme Court to take up, to limit lower courts' authority to issue nationwide injunctions. And I think the court's decision to take up this issue now and in this case is one of the more troubling aspects of this decision. And I say that because the broader context for what is going on right now in this case is an administration and an executive branch that is engaged in some of the more brazen and systematic legal violations that I think we have seen of late, and that is also challenging the idea that the executive branch is subject to the law, and in particular that lower court federal laws against the administration. We are all probably familiar with the remarks that Donald Trump has made, accusing Judge Boasberg, who oversaw the initial Alien Enemies Act litigation, of being a radical left lunatic and calling for his impeachment after the judge issued an order ruling against the administration. We've all heard Vice President Vance's remarks before he became a senator and then vice president, suggesting that the administration or presidents might be able to ignore lower court rulings. For those of you following the testimony that various administration officials have given in front of the Senate, Defense Secretary Pete Hegseth refused to commit to following a lower court ruling that might have obligated him to rescind the deployment of the California National Guard and the Marines in California. But he was willing to commit to following a Supreme Court decision to that effect. Add to that the fact that the administration has been found to violate at least 3 lower court orders. One, the Alien Enemies Act order that Judge Boasberg had issued that directed the administration to turn around planes that had already departed from El Salvador. Second is the third country removal decision that had obligated the administration to afford individuals notice and an opportunity to challenge their removal to a country other than the country designated as a destination in their removal order. And third, the decisions that had halted the Office of Management and Budget's funding freeze that the administration had issued earlier in its tenure. So the Supreme Court blocked 2 out of 3 of those lower court rulings, freeing the government of its continued obligation to comply with them. I worry that the court's decision to do that and then to issue this nationwide injunction now during the first 6 months of the Trump administration, and in a case where the administration's conduct is some of the more egregious legal violations that I think that they have engaged in, signals some loose atmospheric support for the administration's challenges to the lower court's oversight of the administration. There have been so many remarks by various administration officials that suggest the lower court rulings, anytime they go against the administration, are unconstitutional, illegal, corrupt, the real threat to our constitutional system. I understand that the Supreme Court is not agreeing with the Trump administration when it rules for them in these various requests, or the birthright citizenship case when it limits the authority of lower courts to block Trump administration policies on a nationwide basis. But they are providing the administration with fodder and cover to resist the prospect of judicial oversight and to continue to challenge lower courts' ability to rule against the administration. And I think that that is some, or are some of the more troubling aspects of this decision, the extent to which it emboldens the administration's lawlessness and provides them, again, with some cover that is more legitimate than their, unhinged, frankly, attacks on the lower federal courts. So that's one aspect of the decision. And the second thing I'd wanted to say is the extent to which this decision fits a broader pattern of this court as well as previous courts in trimming the sails of the broader project of Reconstruction. So last term, of course, the Supreme Court announced that states could not enforce Section 3 of the 14th Amendment, which disqualified individuals from running for office if they engaged in, insurrection or rebellion against the United States after having taken an oath to support the United States. Previously, the Supreme Court dismantled a key part of the Voting Rights Act on the ground that it, treated some states differently than one another's and unconstitutionally, restricted states' ability to enact laws regulating elections. And again, I think the court's decision to take up this issue of nationwide injunctions in the birthright citizenship case, where the administration is in clear violation of Section 1 of the 14th Amendment, the foundation of a new constitutional order, and to limit the federal court's ability to adopt nationwide remedies for the violation of rights that call for and require a uniform national rule is another way in which the court is chipping away at the project of Reconstruction, this idea of a multiracial democracy with uniform rules benefiting all individuals. And so that is the second, context to this decision that has, stuck out to me. Again, I apologize if any of these remarks are duplicating what others have already said, and I apologize also for missing your previous remarks, but those are the 2 points that I had wanted to make about this particular decision, and I'm happy to answer questions or talk about more in the Q&A.
Thank you for sharing those insights and observations, Professor Littman. I am now going to move on to Professor Soman, and I'm curious from your perspective how you would characterize the court's decision in Trump v. CASA with respect to what it suggests or may indicate about the court's current approach to democratic theory, and more specifically, perhaps the role of the Supreme Court and the lower federal district courts in the broader constitutional framework.
Thank you. So I want to briefly talk about a couple aspects of this decision. One is just why I think it's wrong. Second, what are sort of the alternatives that are still left for relatively broad remedies? Do I think the impact or effectiveness of those alternatives still sort of remain to be determined? And then a very brief word on the future of the birthright citizenship litigation. So if you look at the opinions in this case, both the majority and the principal dissent, a big issue that they are arguing about and has been argued about for some time is whether universal injunctions as they have been used in recent decades are analogous to remedies available in the British Chancery Court as it existed in 1789. And I think both sides have, some potentially good arguments on that issue. They've percolated in law reviews for a long time. I don't really have a strong opinion on who truly is right about that historical question. What I do have a stronger view on, I think this is just a wrong question to be asking, because the whole point is we fought a revolution to be free of the arbitrary government of the British Empire, and therefore we should not assume that the limitations that existed to vindicate people's rights in their system in 1789 necessarily apply in the US. Among other things, there is an obvious big difference between the British constitutional system and what the founders tried to create, which is that Britain did not, and arguably even today still does not, have a written constitution that is supposed to be binding on all government officials at all times, regardless of any reasons they might have for wanting to violate it. And that suggests that the remedies for violations of that constitution in our system should not be dictated by whatever was the assumed portfolio of remedies that might have been available to the Chancery Court in 1789. And I think this deeper principle of the necessity of enforcing constitutional constraints on government at all times and protection for everyone. That's the really deeper principle that's at stake in this case, and it must supersede any considerations that anyone might have about whether a particular remedy is precisely analogous to what existed in 1789 in the British courts or not. Even if the answer to that question is no, if the remedy is still needed to prevent systematic illegality by particularly the federal government, but also by other government actors, state and local governments and the like, then that remedy can still be used, to my mind, because it is necessary to enforce a deeper and more important principle than the specific details of the particular remedies that the British might have thought were appropriate back in the 18th century. And I think Justice Jackson's dissent, although I don't always agree with all of her particular rhetorical points, on the substance, she's right that unless some other remedies can work here, that this creates essentially zones of lawlessness that the federal government and perhaps also some other lower level governments can exploit. In particular, those zones are likely to be most serious when you have unconstitutional government actions that affect many hundreds of thousands of people, which would make it difficult or impossible for all of them to sue. And as she also points out, is particularly likely to be a serious problem if many of those people are poor, uneducated, or otherwise find difficulty going to court. Now, I would also emphasize that this isn't even really about whether a particular district judge's remedy that he or she issues is limited to their district, because this is not really about geographic limits within a district, but rather it's about remedies for third parties, including third parties who might live in the exact same district as the district judge and the plaintiff. So in that sense, the scope of the decision is broader in that. There is a concern raised by many people, including presidents of both parties and some legal scholars. Well, what about the issue of might have a rogue judge, who issues an injunction, that's problematic and stops a policy dead in its tracks, and also there can be forum shopping. Both conservative and liberal litigants engage in forum shopping, trying to find a district judge that they think will be sympathetic to their position. I think this might be a real problem. I think it's significantly overblown because there's an obvious remedy for it, which is that an appellate court can, if necessary, quickly stay an injunction. And that actually happens all the time. To the extent that more reforms are needed, you can argue about random lottery assignment of judges or having 3 judge panels. Those are all reforms that Congress might attempt and can be considered. But it strikes me as this is a much less significant problem than the problem of executive branch lawlessness and lawlessness by government officials more generally, particularly in an era when the powers of the federal government are much greater than they were in 1789. Many of those powers are actually ones that, properly interpreted, don't belong in the federal government at all under the original meaning of the Constitution. But if we're going to have them, they should at least be subject to swift judicial remedies for violations of individual rights, and such structural constraints as still remain. Now, I do think this is not by any means necessarily the end or close to the end of judicial constraints on executive malfeasance or other governmental malfeasance. There, I would not go as far as the dissenting justices and Sellner rhetoric do. How big an impact this will have depends on what effect it will have on these other remedies that are still potentially out there. And I'll just briefly note them. One already mentioned by others is the issue of complete relief. Sometimes complete relief for the parties to a case requires remedies that affect a lot of other people. I should note this is an issue actually in a case where I'm co-counsel right now in the case challenging Trump's tariffs. We have we have clients who are businesses that that import and are subject to tariffs, but we argue the remedy for them cannot just be that they don't have to pay the tariffs because they're also affected by the requirement that other people pay the tariffs, their indirect suppliers, their customers, and so on. And there can be similar things in other cases. Another is class actions, already been discussed. Potentially, they can involve large numbers of people. How effective this will be depends on sort of how tight class certification restrictions are. Also mentioned in majority opinion is state lawsuits, and often a remedy for a state would have to be pretty broad in nature, and at the very least might need to apply to everything within the territory of that state. But given mobility and interconnections between different states, it might need to be broader in that in some context. Exactly how broad is a question the majority didn't answer. Also, this is tied in with the long controversial question of state standing to bring lawsuits and when they can do that. I have long been an advocate of broad state standing, but not everybody, sadly, not everybody agrees with me on that issue. And the Supreme Court is sort of blown hot and cold on, when states have standing and when they don't. Also, as noted in the piece by Jack Goldsmith a day or two ago, and also in Justice Kavanaugh's concurring opinion, there is the notion, well, maybe the Supreme Court will be the ultimate arbiter of this, and if a case gets to the Supreme Court and the Supreme Court issues a ruling, then everybody will have to obey it. The Solicitor General even promised that the Trump administration would do this, and I think we'll have to see how well this works. There are various potential problems with it. My sort of possible reservation is that Justice Kavanaugh is also the guy who has complained that the Supreme Court doesn't take very many cases. There's only a limited number of cases which get to the Supreme Court, even if you count the shadow docket cases. So I think it's problematic to say, well, all these issues have to wait unless and until they get to the Supreme Court, which for some might never happen or might take years. And then finally, this is a statutory case, not a constitutional one. Therefore, at least in principle, a future Congress could pass a law restoring universal injunctions or partially restoring them or doing other kinds of reforms. Finally, on birthright citizenship, this decision has delayed the implementation of the order by 30 days. That gives time in lower courts for them to consider various issues like class actions, which have already been filed. Also, the issue of how much relief states might be entitled to. And so I remain somewhat optimistic that ultimately this birthright citizenship order will not be enforced against any great number of people for any great length of time. I'm less optimistic about some other types of rights violations, in particular where class action standing might be harder to get. But I could be wrong about that, because the issue of how effective these other remedies are going to be, that is sort of an unanswered question left over from the opinion that was issued on Friday. Thank you.
May I cut in for 1 second to say that we had a technical glitch and we do not have the chat open for questions. So if you would like to ask questions of the first panel, I'm going to give you the last panelist's time to send them to me, and then you can send them to me throughout the second panel. I'm going to have to receive them via email, I've been told. So my email address is my last name, which should be up here, SIEGEL, the first 2 letters of my last name, AN@seattleu.edu. So it's a cumbersome way to get the questions. Panelists have so much to add that I'd love to give you the opportunity to send them to me.
All right, so while we allow everyone the time to send their emails and their questions to Professor Siegel, I'm going to turn over the floor to Professor Brewer, our resident legal historian on the panel. From what historical lens should we perhaps view this decision in order to best appreciate and understand the court's opinion in Trump v. CASA?
So, as many people have talked about today, Barrett overturned what has become a widespread tool of the lower courts, that is nationwide or universal injunctions, on the grounds of claiming that at the time of the founding, or she put it in an exact quote, universal injunctions are not sufficiently analogous to any relief available in the court of equity in England at the time of the founding. So that was her basis for overturning this long-standing tool. And to me, it's absolutely bizarre to undermine an essential and long-standing tool of the courts to uphold the law, and especially to keep a president in line when he's issuing orders that go directly against the Constitution, by this kind of historical argument that is, in my view, on very thin ground indeed. And so while Professor Summon was just talking about, there are arguments on both sides, I really don't think there are, or not even at least ones that make any sense to me. So what Justice Barrett was referring to is language in the 1789 Judiciary Act that, quote unquote, the circuit courts shall have original cognizance concurrent with the courts of the several states of all suits of a civil nature at common law or in equity, end quote. And there's other references to equity, but that's the main place. And what she was referring to was and the decision is to the High Court of Chancery, as it was called in England at this time. It was one of 4 high courts in England in the late 18th century. The other 3 were more traditional common law courts, which I can answer questions about if you want. But it was really important. It was a separate court system to the common law and particularly set up to provide remedies for defects or omissions in the common law, which could get sort of stuck in ruts. It was a real court, but it was also a principle that one could appeal to equity for relief when one could not find it in the common law courts. In other words, it was a principle of alternative ways to seek justice when the regular law was clearly problematic. And it was thus that Associate Justice Story in his 1839 commentaries on equity jurisprudence, he was also an Associate Justice on the Supreme Court, and who was cited by Justice Sotomayor in her dissent, could talk about how equity adapted to the varieties of circumstances which may arise and adjust them to all the particular rights of all the parties in interest. And as she also pointed out, this is again in a direct quote, equity's constant aim was to do complete justice. So in other words, there's a principle at stake behind these courts, and it wasn't just precedents of this particular chancery or equity court. The 2 words were used interchangeably. But more generally, the problem that's going on with Barrett's argument is that many colonies had separate chancery or equity courts during the colonial periods, not all of them, but it was often the same body, the same general court in Virginia, which would hear chancery cases as the others. And after the Revolution, most states got rid of them. And so generally it was just the regular high court that would hear equity cases and say equity principles. But during the colonial period, the rulings were incorporated into and cited in court decisions on the colonial level, and they were reported and then followed as guidelines for what the law was. So Thomas Jefferson, who was learning the law in the 1760s before the Revolution, took courts on such equity or chancery reports, as well as on common law reports in his legal notebooks, which we still have. When he donated his library to the University of Virginia at his death, at least 6 of the more than 300 books were about chancery or equity decisions, showing that they were used as guidelines. My point is that while relying on such reports was not exactly the same as a universal injunction, in some ways they functioned that way, whether from high courts of common law or chancery, so that they have a much broader reach. So that Barrett's central claim is in fact completely misinformed in terms of the actual history, or I would say. And so that when the Judiciary Act gave federal district courts equity jurisdiction, it was not just over a particular body of law, but also more generally a capacity to deal with situations that are literally inevitable and that, yes, would have broad standing and impact. The bigger point is not just that Justice Barrett got this history wrong. It is that resorting to history of 250 years ago to overturn one of the only ways that the current president's manifestly illegal actions are being kept in check, and to overturn not just the reach in this case, but in the dozens of other cases where such injunctions have been used to stop or hinder this president's illegal action, re-enables those illegal orders that this president has given. So it's thus that, although there might be some other alternatives, and various people in this discussion so far have mentioned, oh, well, we can turn to this, we can do this instead. It's that at this moment, it overturns most of the ways that the current president's orders have been stopped. So it's although I agree there's a little bit of superlative language in some of what Justice Sotomayor and Justice Jackson have said that the impact of these in the immediate sense of this decision is to remove the restraints that have been put on this president's executive orders. So I'm just going to give a few quotes to give a sense of what I think is most important about what they're saying. And so Justice Sotomayor says, the president, quote, orders patent unlawfulness underscores why equity supports universal injunctions. It is one of the few ways to stop an illegal order. Sotomayor continued, quote, the executive branch has no right to enforce the citizenship order against anyone, end quote, because it is, quote unquote, unquestionably unconstitutional. Moreover, issuing the temporary stay in the judgment, which is what the lower court had done, requires that the Supreme Court, reversing the temporary stay issued by the lower courts requires that the Supreme Court show that the president is irreparably harmed by the lower court's injunction. And I just love this line from Justice Sotomayor. She says, simply put, it strains credulity to treat the executive branch as irreparably harmed by injunctions that direct it to continue to follow settled law. Justice Jackson, I'm just going to give a couple quotes from her to emphasize key points that she makes that I think are exactly on target. Is our rights-based system can only function properly if the executive and everyone else is always bound by the law, end quote. And this Constitution is flipped on its head, where its promises are essentially nullified, is arguably, again, a little bit too strong on the grounds that there are other possibilities that can be brought up, but this has been the main one. And I'm going to end with just an anecdote. I got a text message from the Attorney General in my state, Maryland, yesterday saying, essentially, we now, because of this court decision, have to relitigate all of these cases we've been litigating for the last 5 months to defend against executive orders. Would you please donate some money? This case literally is going to overturn tens of thousands of hours of efforts on so many fronts, way beyond birthright citizenship.
Thank you to the panelists who've done a wonderful job with the first panel. I think that we have enough time, since we have a slightly smaller second panel, to ask some of the questions. I've received about 10 questions, and I think I can group them into 2 categories. So I'll ask one category of question, get some responses from the panelists, and then I'll ask the second category of question. The first thing that people seem really interested in is the alternatives. They want to hear more. In particular, they want to hear more about 2 things. First, they'd like to hear more from the panelists about when nationwide injunctions might still be available as necessary to provide complete relief. More examples of how that might work out, maybe from the current litigation, situations where that might apply, whether we think that some of the current Trump injunctions are going to pass that test. And the second thing they want to hear more about is class actions. How good a fit is class actions? How quick and adaptable are class actions as a remedy? And are the courts going to end up being just as hostile to class actions as a remedy for these kinds of executive encroachments that they have been for nationwide injunctions? So first, on those 2 issues, on continuing nationwide injunctions for complete relief and on class actions as a substitute. Love for some of you to jump in.
I guess since I have to get off in a few minutes, I might as well try. Complete relief is sort of a fuzzy notion, whose impact is going to vary a lot from case to case, and it won't always be able to tell what complete relief really is, and can you impose large limitations on third-party effects in order to make relief just a little bit more complete for the parties to a case. I think there's going to be a lot of variance case to case. In our tariff case, which I mentioned before, there is the argument that you can't really provide complete relief to particular individual businesses or particular individual states unless you forbid these tariffs throughout the country, because otherwise the interconnected nature of the economy means that people will still suffer negative effects even if they're not personally paying the tariffs, or even if their state is exempt from the tariffs but goods imported into other states are not exempt from it. In other cases, that may or may not be a similar situation. On class actions, there is a long-standing debate over how tightly the rules about class action certification should be enforced. And again, it'll be difficult to say how it plays out in different situations, but I would note that just a few weeks ago in another litigation I watched closely, the Alien Enemies Act litigation, the Supreme Court actually did what essentially was sort of a shadow docket midnight intervention, almost literally midnight intervention against the Trump administration, where they accepted that there could be a putative class of people who might be subject to deportation under the Alien Enemies Act. And one can imagine other putative classes being the subject of a temporary injunction, and then you later then can litigate the issue of whether a class should be permanently and fully certified. Again, how broadly that would apply, this is not something the court really shared with us in that Alien Enemies Act case, the AARP case, which should not be confused with the American Association of Retired Persons. This was like a person whose the initials amount to AARP, and that's why the case was so named. So again, with both of these devices, I think they have clear applicability in some situations, but how broad it will be generally, that's a thing, that's very difficult to say, even though obviously the questioners and certainly I would like to know more about, how applicable they will be.
Anybody else want in on either of those?
I'll say something on the class actions part. Something to think about with that is, in that way, this case is a great place to think about it, because how in the world are you figuring that out, right? In terms of who might be pregnant in that scenario, those specific scenarios at some point. This starts bringing up some kind of strange litigation, which I think is commendable to try given the constraints we're in. But it's like every few months, you need to refile, right? Because you have different people who would potentially be in the US giving birth in those situations, right? So I think that shows some of how class actions are going to be a very difficult place for this. Also, because some of what Leah Littman's written about, right, with remedial convergence and collapse, in terms of whether these things will actually be available. But yeah, I'll leave it at that.
I'll actually just want to add one thing, is that in addition to the issues mentioned with class actions, there's also, Alito tipped it off in his concurrence, that standing issues too, especially if we're talking about states having maybe greater latitude to demand a broader type of relief. If you're getting into maybe one of the safest ways to get this type of relief coming through states, then you definitely will have a standing issue coming up. And even though the standing doctrine has kind of expanded in recent cases, I would go back to the Massachusetts EPA case, environmental case challenging unenforcement of global warming initiatives. I would say that even if though it has been expanding, that may not be the case all the time. And it raises the question of maybe third-party standing. If these aren't the state's rights or clear harm to the states, how can the states have standing too? So I just wanted to flag that it even goes beyond the class action issue to standing as well. And it's hard to predict. I raised a question about the administration acting in good faith. I also can raise questions about the court acting in good faith and try to imagine what would happen even under the regime that they've now created. All right, how would they follow up with that? And it could be by cabining these procedural rules as well, in order to box out the opportunity for people to have remedies.
Okay, the second set of questions, and if we could just get a few quick comments on this, this is a topic that we could talk about for hours, is about the politics and policy of this. One questioner said, basically, you guys have made such a good case that they don't understand the arguments on the other side, that they don't understand in a world where your opponents might have power, why you'd want to disarm the courts from stopping illegal and unconstitutional actions of great severity. So a little bit about the policy on that side. And then one of the panelists actually wanted to mention and bring up the subject of kind of in line with that, there's kind of this notion that there's been bipartisan administrative and political opposition to nationwide injunctions, and wanted to talk about whether that's actually true or whether it's a newfound thing stemming from the Trump administration to have the administration so hostile to nationwide injunctions. So a little bit about the history there, but mostly the politics and policy of why you'd be opposed to nationwide injunctions.
I wanted to say something about that last point, and Leah certainly talked about it, which is, and I don't think it's new to this administration, but the tenor and tone of how the current administration does not respect and has created a sort of culturated the idea that a district court opinion need not be followed, which is not true. You stand in potential contempt of a federal district court order, or any court order for that matter. But I think that has been a shift. Prior Democratic administrations have certainly offered some criticism of national injunctions, and internally would have had debates about, well, should we try to test it maybe in a different circuit or try to create a split, but they would have respected the order and then would have quickly sought some type of emergency relief. And that goes back to, I think, the first question, which is, this is all going to get worse before it gets better if you are on the side of wanting lower courts to do this, because it's stripping away lower courts' ability to be involved. So that means everything's going to have to go to the Supreme Court on it. I'd be interested to see if they take up things on free exercise rights on the emergency docket, and where we've seen the increase, right, a protection of rights there. Are they going to have everything have to be a class action, or are they going to move faster and make some sort of broader statements? But in terms of opposition, there's been loud opposition by several scholars that were arguing before Congress, and this is the one that Steve Vladeck was in favor of having lower courts do this, but you had Professor Sam Bray and others who have said repeatedly that this is too far because it goes to non-parties. And I think that piggybacks on something the court had been doing with punitive damages, about punitive damages not being allowed to punish non-parties. And I think that decision, State Farm, or Philip Morris rather, was wrongly decided for different reasons, because it's under different constitutional analysis. But I think that notion of this overreach, and that the court itself, whether you believe they're in good faith or not, the court wants to be a part of gaining more credibility by saying we're going to rein in what could be perceived as overreach, especially on partisan issues, even though it's doing other things, right, that sort of fall on the face of that.
The only thing I was going to add to that is that, sorry, Portia, do you want to go? Okay. The only thing I would add to that is that it's true that previous administrations have asked the Supreme Court to rein in nationwide injunctions, in particular the Biden administration. But the Biden administration was on the receiving end of nationwide injunctions, primarily from a few extremely ideological rogue judges in Texas, where plaintiffs could pick those judges by choosing to file in single divisions where they were guaranteed to draw those judges. And so the administration was subject to, I think, a fair number of completely unwarranted lawless injunctions, and that precipitated a lot of the criticism and concern about nationwide injunctions. And then I think what the Trump administration has done is they basically leveraged those legitimate concerns with nationwide injunctions and use that to give them some cover to just resist the prospect of judicial review at all, because they've been on the receiving end of nationwide injunctions from judges that have been appointed by basically every president, in a myriad different circuits. Whereas if you look at the statistics that Steve Vladeck, at Georgetown has compiled, the different numbers as far as who was issuing injunctions against the Biden versus Trump administrations are stark. I think it's something like all of the nationwide injunctions that the Biden administration was subject to came from Republican appointees, save for maybe one on their attempt to do another student debt relief initiative. But even that, I don't even think was a nationwide injunction. So, yeah.
And I think just to say on this, because people keep saying administrations, depending on how you count, 2 or 3, right? 2 Trump administrations, 1 Biden administration. And before that, so before Trump's candidacy, this didn't exist as a term, as a thought, as a conception of types of injunctions. So before around 2016, when scholars began publishing on this, there wasn't even a Supreme Court discussion of this. There were people who were against prophylactic, structural injunctions, et cetera. But this only came about when Trump was the candidate. And that's something important, not to say that it's completely irrelevant, but to say that I wish that people, even within the Biden administration, had understood that what you do when you think that a decision is wrong is not to go after the remedy and attempt remedial retrenchment, right? Attack to get the remedy taken away when you actually want to change what the right is. If you think something's wrong, it's if the remedy is improperly given, then you need to go through stays, appeals, et cetera, instead of just trying to get a new scene type of remedy taken away. So I think there is something with ideological motivation here. In addition, that more of what's going to happen is going to be for civil rights, left-leaning plaintiffs and rights and marginalized groups than what will be lost for right-leaning plaintiffs and corporate plaintiffs.
Thank you so much, Portia. Holly, I think we're going to move on to the next panel. All right. Thank you all so much. Thank Erin for doing a wonderful job moderating. The first panelists are absolutely welcome to stay on and listen into the second panel and pipe in on the questions if they have something to say. But also, we know you've got a lot of obligations, so feel free to go take care of those things. It's just going to be a slight shift going to the next panel. We're going to talk about a lot of the same things, but the focus is going to shift slightly to discuss more about the merits of the birthright citizenship issue and maybe more directly, although we've been doing it pretty directly, ramifications for reining in the Trump administration in a variety of other contexts. So I am not going to spend as much time on the introductions of the second panelists as Erin did on the first, not because they are not equally impressive, but simply because we're running a bit behind in time. I'm going to take them one by one. Our first panelist is Anthony Michael Kreis from Georgia State. Anthony is a professor of constitutional law and political science, a historically inflected political scientist who's written big and interesting and important book about American constitutional development and its interactions with politics, and has also more recently written directly on the historical issues related to birthright citizenship. So hopefully you can start us off, Anthony.
Well, I'm so glad to be here, and I appreciate everybody joining for this. I think it's really important that we have these conversations. So I think I think this is a really complicated issue for maybe the wrong reasons. What I'm concerned about right now is where this litigation goes now that the Supreme Court has kind of taking care of the first step of the birthright citizenship litigation, and now that they're going to have to get to the merits. I want to just start off, I think, briefly to highlight what I think is really important here, which is this is one issue that everybody, I think, should be on the same page. We should all be in agreement. Originalists, more progressive constitutionalists, textualists, everybody, everywhere in between. I feel like we should all be on the same page. And I think that for one reason, we have a really, for the most part, unbroken, in my view, tradition of birthright citizenship. That means that people who are born on U.S. soil, by virtue of being born on U.S. soil, are native citizens, and that's that, right? It is not open to debate. It's not a question. It's not a close call. And this tradition is an Anglo-American tradition that goes back for many, many centuries. And so a lot of people talk about the common law tradition of birthright citizenship. And so things like Calvin's case, which is perhaps the most clear early articulation of the concept of birthright citizenship, which comes from England in 1608. We have a written historical record to show that, or that demonstrates that this has always been the kind of or a bedrock principle of English and American law, right? We have all of these decisions. We have earlier English statutes that predate Calvin's case, but fundamentally, this is a principle that American law adopted from England, and it's been clear cut. So I want to, the other thing I want to emphasize about this is that when Americans deviated from this legal principle was only in the Dred Scott decision, in which the Supreme Court essentially said that Black persons could never be citizens of the United States, that they were never intended to be part of the American body politic, and the 14th Amendment was intended to reverse that decision, which deviated from the common law rule. I think the text of the 14th Amendment is plainly obvious that that's exactly what they were trying to do. They were trying to restore that common law rule. And the Supreme Court has since, in the late 1800s, reaffirmed this idea. We've had an unbroken practice and tradition of adhering to this very simple principle of birthright citizenship ever since the 14th Amendment was ratified. The fact that we're suddenly having this debate now, I think, is really shocking. The fact that there are people who are writing about this, who are trying to take what is an off-the-wall idea and put it on the wall to suggest that there is an open-ended question, I think is anti-constitutional. The whole point of the 14th Amendment and its codification of birthright citizenship was to foreclose this debate, right? We were not supposed to be having this discussion. We're not supposed to be here. And I find that really, really troubling. And I find it really troubling because what we're seeing is, in my view, the emergence of really bad history. I think this court, for example, has had a really kind of trying or has a really trying relationship with getting history right. And I think we're seeing people in the public space and scholars and other commentators begin to do bad history for this court. And so I'm really very concerned about the future of this litigation and what this court might do with that history once this case gets kicked back up to them. I'm really loath to think about what this court might do when this case gets back up to them. I have always really believed that this was an open and shut case. I didn't think there was any disagreement. I didn't think there'd be any real debate about whether or not the president could do this. And it just seems to me I have a lot more to worry about now than I did a few weeks ago. So that's kind of where I'm at with this right now. But again, the history here is just so plainly obvious to me. The rule should be just so plainly straightforward and widely understood. There should be no debate. And I think that what we're witnessing again now is that this seems to be a live question. And I'm really very, very, very concerned about that. And I want to emphasize what I think is what we all should be doing in conversations like this, which is to be true about to be true to the history and to have people understand what the history of the 14th Amendment is, what the common law rule of birthright citizenship was, why we have this. I think it's really important for the public to understand this and to understand what's really at stake. I'll kind of wrap up with this, which is, what really pains me is that, we're seeing the use or the kind of perversion of history and I guess are turning our backs, or some folks are turning their backs on I think a really precious legal tradition. and they're doing so in a way that causes real harm. I don't want to lose. I don't want to lose sight of what's really at stake here, which is, there will be children, if this were to be upheld, there would be children who would be stateless. Right? This is not one of those things that's kind of a I don't know. It's not academic. It's not fun and games. And I think what we've seen from a lot of folks in the public square lately is treating this like it's an academic exercise and that it's all fun and games. And I think the courts. I'm just really worried about that. Like the way this debate is unfolded, and I really hope that things like this, conversations like the ones that we're having today, drive the dialogue in a much more healthier and honest place, and that the court doesn't do what I hope they won't do, which is buy into some of this bad legal history and undo, or at least undermine in some way, one of the most, I think, cherished and well, I guess important traditions in our constitutional order.
Thank you so much, Anthony. That sets the stage very well. We're going to hear from one of your co-authors later, so you might hear more about your ideas about birthright citizenship. The next speaker is Seattle U's own Jessica Levin, who is the co-director of our Center for Constitutional Rights and Civil Rights and Critical Justice. We've recently changed the name, and is an accomplished civil rights litigator, teacher of our civil rights clinic, and a co-author of a significant amicus brief in one of the cases filed against birthright citizenship. So I look forward to hearing from her.
Thank you so much, Professor Siegel, and good morning, everybody. As Professor Siegel mentioned, I co-direct the Center for Civil Rights and Critical Justice here at Seattle University School of Law with Professor Melissa Lee. My contribution to this panel, which I think actually our speaker just before me provided a perfect transition, but really the contribution to this panel is an overview of the points made in the amicus briefs we submitted in the birthright citizenship litigation by our own center, by the Asian American Legal Defense and Education Fund, the Korematsu Center for Law and Equality at UC Irvine School of Law, and O'Melveny Myers. Together, we filed briefs in the First, Fourth, and Ninth Circuits on behalf of 84 amici from across the country. And these amici are predominantly Asian American grassroots and nonprofit organizations and bar associations, as well as members of the Race and Law Center network. These amici represent communities that have long been targeted by governmental efforts to strip or deny citizenship on the basis of race, on the basis of gender, and on immigration status. Our briefs offer critical historical context of periods in our country's history when the government has pursued citizenship stripping just as it is at this moment. Our brief also warns of the constitutional, legal, and human consequences of the citizenship stripping order, which I will discuss a bit later. So as we well know, the Citizenship Clause was enacted to remedy the harm of the Dred Scott decision, where the court held that Black people could not be citizens. The amendment Citizenship Clause was meant to ensure that race would never again be used to deny belonging. But the historical record provides many examples of how we as a country have time and time again failed to live up to the promise of the Citizenship Clause. So we wrote this amicus brief with two goals in mind. First, we wanted to shed light on two specific historical examples from the early 20th century when our government pursued citizenship stripping of both naturalized and birthright citizens alike. And we wanted to remind courts that these historical examples are rooted in racial animus and xenophobia. Second, we wanted to underscore the potentially devastating human and legal consequences of upholding the current order, which Anthony just urged us all to consider. So let me begin with the two historical episodes from the earliest 20th century discussed in our brief. One is regarding denaturalization proceedings in the 1920s, and the other is regarding stripping of birthright citizenship at the turn of the century. These two episodes underscore the impact of citizenship stripping that has either been outright targeted or otherwise had an outsized impact on Asian Americans, and hence the group of amici, 84 amici that came together to really underscore these historical examples. The first is the case of United States versus Thind. Before discussing what happened in that case, I want you to remember that our country's earliest naturalization criteria revolved around who our government was willing to define as white. The 1790 Naturalization Act limited access to free white persons. And so following the Civil War and Reconstruction amendments, Congress amended the act to allow Black people to naturalize in 1870, but other groups, particularly Asian immigrants, remained excluded. So in 1923, in United States versus Thind, the Supreme Court held that South Asians were not white. They did not fall into that racial category and were thus ineligible to naturalize. So in response, the federal government launched a denaturalization campaign. Over 50 South Asian Americans lost their citizenship, including the attorney who had argued Thind's case before the Supreme Court in 1926. These were people who had served in the US military, who had paid taxes, who had started families, and they were told they no longer belonged. The government leveraged the courts not to protect citizenship, but to erase it. In our amicus briefs, we highlight the tragic story of Vaishno Das Bagai. He naturalized in 1921, so just a few years before the Thind decision. He ran a business in San Francisco and brought his family to the US from India. After the Thind decision, the government initiated denaturalization proceedings against him, claiming he had illegally obtained his citizenship by claiming status as a white person. He lost his job, and then he lost his property, because once denaturalized, he could not own property under the California alien land laws in place at the time. In 1928, he took his own life, with his suicide letter stating, "Now, what am I? What have I made of myself and my children? We cannot exercise our rights. Obstacles this way, blockades that way, and the bridges burnt behind." His case is a stark reminder that bureaucratic denials of belonging can not only upend lives, and we'll talk about those impacts later, but also end them. The second example from earlier in the 20th century that is crucial to bear in mind as we prepare for the possible implications of the birthright EO is the Expatriation Act of 1907. So in that act, Congress stripped US-born women of their citizenship if they married non-citizens. Many women affected by this congressional act were Asian American. This gendered law presumed that a woman's allegiance belonged to her husband, not to her country. And so even when Congress repealed certain aspects of the Expatriation Act in the Cable Act of 1922, many women, again, disproportionately Asian American women, were doubly burdened. They lost their US citizenship in 1907 by marriage, and then were nevertheless barred from regaining their citizenship because they were racially ineligible to naturalize. This, of course, left them vulnerable to deportation, left them ineligible to vote. Again, despite the passage of the 19th Amendment in 1920, and of course also negatively impacted employment and freedom to travel. And just as we highlighted the individual story of Vaishno Das Bagai to tell the story of the human toll of the Thind decision, we highlighted the story of Ing Fung Sing to tell the story of the human toll of the Expatriation Act. Singh was born right here in Washington, in Port Ludlow, in 1898 to Chinese parents. Singh was a birthright citizen due to the Wong Kim Ark decision earlier that year. When she was 5, her parents took her to live in China, where she married a Chinese citizen. When her husband died in 1925, she came back to the US but was denied entry. The Expatriation Act had stripped her of her citizenship, and the Chinese exclusion laws in place at the time meant, again, that she was ineligible to naturalize. Had Singh been white, of course, she could have regained her citizenship as a widow. These two examples and these legal historical examples illustrate how the law has historically been weaponized against women and communities of color in ways that echo today's threats. And so when we have this conversation, we cannot have it in race-neutral terms. The other main point of our amicus brief, particularly given the historical examples that we discussed, is the danger of retroactive application. The citizenship stripping order is framed as prospective, but the amicus brief warns that it opens the door to future retroactive revocations of citizenship. Although the order states that it only applies to children born after a certain date, if the court ultimately upholds the order as constitutional under the 14th Amendment, the possibility of retroactive application becomes a reality. As a general proposition, when courts interpret the meaning of a constitutional provision or amendment, that interpretation is considered to be what the Constitution has always meant. So this means that any potential holding by SCOTUS that birthright citizenship is not guaranteed by the 14th Amendment opens the door to broader attempts to strip citizenship. And what the historical examples really show us is that citizenship stripping efforts by one branch can and do embolden such efforts by coordinate branches. So for communities of color, especially those that are already targeted by immigration enforcement, this amplifies fear, instability, and exclusion. It is all too easy to imagine this administration trying to strip citizenship retroactively. In that scenario, without further intervention from Congress, the affected individuals would become undocumented, with many or most becoming stateless, as was just mentioned before. Indeed, because those individuals never naturalized due to their presumption of birthright citizenship, their presence in our country might be deemed unlawful. At minimum, they would lose access to the right to vote, they would lose access to safeguards against family separation and access to federal and state employment opportunities and benefits, and that is just the beginning. So our amicus brief warns that allowing this citizenship stripping order to stand could create a permanent underclass of stateless people. Without citizenship, they lose access to, again, critical public services, and many could face deportation from the only country they've ever known. And when we contemplate about, the sort of specter of retroapplication, and I think there are perhaps a variety of opinions as to how likely that is to come about, we don't need to speculate about the nature and extent of the harm faced by this class, faced by those who would be affected. So the final point our brief makes is to tell the stories of current harms that are already unfolding in our communities, and ones that Justice Sotomayor's dissent recognizes in full force as antithetical to equity and as an assault on our constitutional order. So I'll end with the story of Teresa Lee. We told this story in our brief. She was a formerly undocumented immigrant of Korean descent who was the inspiration behind the DREAM Act. When she was a child, her parents' status expired and the entire family became undocumented. Her parents struggled to find employment and their family lived in extreme poverty. However, her younger brother was born here. He was a birthright citizen. While Teresa struggled as a student and assumed she could not attend college because of her immigration status and presumed her ineligibility for financial aid, her little brother grew up facing no barriers to education or work. He received financial aid, he found a job after graduating, and he now works at a major fintech software company. So Teresa's story really is a microcosm of the plight of children in mixed status families. And again, we need to look no farther than the experience of those individuals in our country to really understand the harms that are threatened by this citizenship stripping order. So really, at the end of the day, our amicus brief urges courts to recognize that citizenship stripping order for what it really is. It is a dangerous revival of race-based citizenship exclusion. The EO is a major part of this administration's playbook to reinvigorate this dark era in our nation's history. And our hope with this brief is that it urges courts to keep these historical examples at the forefront as they continue to adjudicate these cases. Thank you so much for the time, and I'll be happy to answer questions at the end.
Thank you. Thank you so much, Jessica, for those moving words, for the amicus brief itself, for telling the stories and making the arguments here. Our next speaker is Robert Tsai. Robert is professor of law and Harry Elwood Warren Memorial Scholar at Boston University School of Law. He's been with us in the past, and we really appreciate his return. He writes about political culture, legal change, democratic design, inequality, and popular sovereignty. And I think pretty much every one of those is implicated by the issues and the decisions here. So I'm going to kick it over to Robert. I expect to hear more about birthright citizenship and kind of how it fits into patterns of inequality and strategies of resistance.
Hi, everybody. It's great to be with you. Before I begin, I just wanted to say that I'm on record with much of what Anthony has said. That is to say that the 14th Amendment's language is clear in covering the children of unauthorized migrants born in the United States. I also want to co-sign what Jessica said, that this executive order, if it were to be enforced, would create all kinds of problems that are better off avoided. What I want to do with the time I have is to talk about this particular decision, though. This decision that ends or purports to end universal injunctions, but also has the effect of ducking the merits of this question. Here's what I want to do is I want to try to talk about it against the backdrop of two dynamics. One is the rise of judicial supremacy during the 20th century. And second, to think about the effect of this ruling in terms of constitutional politics, especially in an age of populist presidents. So first, I think we have to think about the order here and the issue of injunctions against the general rise of courts playing an active role in democratic life. This is a problem, that is to say, at least the problem of judicial supremacy, not just for conservatives and libertarians, but also for progressives who should see that judges don't have a consistent or coherent theory of democracy, even when they do choose to act, and that judicial review is often deployed selectively to strike down popular laws and to create doctrinal obstacles to democratic organizing. Second, when we think about the populist leaders that are in power, but also the ones who may come to power down the road, they come in more than one flavor. So a maximalist belief in judicial review, too much worry about courts not having all of their tools in front of them, this belief itself empowers unelected judges to block the policies of not just a right-wing populist like Trump, but also future populist figures on the left who may emerge down the road. So our criticism of particular decisions like this one and our hope in the courts, I think, should be tempered by our history and any belief that you have in democracy and constitutional politics going forward. Because history shows us that deep constitutional questions can't be solved through judicial orders or universal injunction. Furthermore, judges cannot stop a populist president. They can only do two things. One, they can help clarify the democratic stakes of certain disputes. And two, they can buy time for alternative politics to assert themselves. In terms of this decision, as Jack Goldsmith of Harvard recently noted, it's not clear that the decision is, unalloyed good news for executive power. But what it does do, it accrues more power to SCOTUS at the expense of lower federal courts. What the new ruling does then is to give SCOTUS yet another tool by which to manage the lower federal courts and to intervene, perhaps to drag out proceedings by tinkering with remedies while not addressing the merits of a constitutional question. Well, is this good or bad to have this other tool? Well, I think it kind of depends on things that we don't yet know a lot about. But in my book, Practical Equality, I called these strategies of delay that we see in this case, strategies of deferral. And there are a few reasons why SCOTUS might wish to engage in strategies of deferral. First is when a question is deeply controversial, and it might be hard to reach a clear consensus on the issue within the court. Second, when the court might wish to avoid direct conflict with a co-equal branch. Third, when the court is inundated with legal challenges and wants flexibility to sift through cases and find the ones that truly require the justice to try to forge a consensus and weigh in. Now, the court has deferred difficult constitutional questions in the past. For example, they deferred the question of interracial marriage for decades, while the federal courts were occupied with the desegregation of schools and other public institutions. And we also saw strategies of deferral used by the Supreme Court of the United States to defer questions raised in challenges to criminal procedures. Now, I think all these conditions that I mentioned are true when it comes to birthright citizenship, which involves a signature issue of a populist president that has been returned to power by the electorate. Birthright citizenship today is a contentious issue in the political realm, even though it has long been a settled issue as a matter of Supreme Court jurisprudence. However, populists of all stripes, whether they come from the left or the right, seek to create legal vehicles to tee up opportunities for reconsideration of long settled questions. This is just a historical fact. This is true of abortion, and it has been true of the appropriate scope of the administrative state. And it also is true here in terms of efforts to get the Supreme Court to overrule or to narrow Wong Kim Ark and alter the court's interpretation of birthright citizenship. The court's not yet inundated with birthright citizenship cases, but they do have many legal challenges to a wide array of Trump policies. And surely the justices do not want to weigh in on all of them, which might make the court, already unpopular, even more of a target. So what might happen here? I think it's clear that the Trump administration wants clarity. They want the case overruled. They want to be vindicated. So do the three dissenters, the remaining liberals, in a populist age when what appears to be a settled constitutional question is now seemingly under pressure. It's not apparent yet, though, how many of the 6 conservative justices want to be on record when it comes to birthright citizenship. So the strategy of deferral for now denies the Supreme Court's imprimatur on an outlier constitutional interpretation and avoids what I've called tragic precedents while buying time. I think it would be a tragic precedent if, merely through judicial interpretation, a class of people living in the United States were once again categorically rendered non-citizens as a matter of fundamental law and potentially stateless. If there's no circuit split on this question of birthright citizenship below, the status of quo jurisprudence on 14th Amendment holds, and the remedies are carefully tailored to the parties in those cases, then perhaps the Supreme Court will stay out of this issue, knowing that Trump's executive order will be withdrawn the moment that the White House changes hands. This is not unlike his travel ban. That would allow the matter to be resolved through ordinary politics and avoid an ugly split on the court that might lead to the rewriting of the 14th Amendment by unelected justices. And don't forget, the executive order is forward-looking, applying to children born 1 month after it was signed. No one yet has been denied papers or blocked from reentry. No one, as far as we know, is undergoing a process of citizenship stripping under that executive order. Will the court intervene more often because of this decision to help Trump's agenda? I think it's too early to say. Ketanji Brown Jackson, in her dissent, worries about, quote, zones of lawlessness created. And Sotomayor also worries that you could have clear principles, but then violations of the principle. I think these concerns are valid, but what they're really just talking about is the problem of under-enforcement, which always exists to some extent. And in most circumstances, compliance with constitutional principles requires respect and voluntary action rather than judicial orders. Nothing in Trump versus CASA changes that, but it does highlight once again the importance of elections to ensure virtuous leaders and government employees who obey the courts. Under-enforcement can also be met through local and state politics and creative grassroots efforts. Here's a final thought on nationwide injunctions as I wrap up. I actually believe that reform would be worthwhile. And indeed, Amy Coney Barrett's ruling points to a problem of judge shopping. But reform should be done broadly and through Congress and not selectively by a handful of justices. This ruling raises more questions than it answers about how litigation proceeds going forward. As others noted, class actions and other avenues remain open, at least in theory, and they may be able to provide similar relief. This decision, though, does nothing about judges in single districts, nor does it end judge shopping, behavior that bedevils presidents of both parties. It also does nothing to make the exercise of judicial power more predictable or cut it down to size in a way that's beneficial for democratic decision-making. So if you believe in the need for more legislation to fix longstanding problems in society, you cannot be, I think, for either the status quo or the current state of judicial supremacy. Federal judges should not be allowed to so easily upset intricate legislation over things like healthcare or interfere with the legitimate administration of the laws. And I'll stop there. Thanks so much.
Thank you so much, Robert. We have 2 more speakers. And we're going to move on to the next one quickly as we're running down on time. The next speaker is Evan Bernick, professor at Northern Illinois University, prolific scholar on constitutional law, administrative law, philosophy of law, and a variety of related subjects, and a co-author of an important article with several others, including Anthony, on the history of birthright citizenship. Take it away, Evan.
So birthright citizenship is guaranteed by the 14th Amendment, full stop. You don't have to be an originalist to see it, although if you are an originalist, you should see it. Nothing that anyone has managed to uncover over the course of several months of research under very questionable epistemic conditions has done anything to dislodge the conventional wisdom. The professors who have produced drafts seeking to challenge the conventional wisdom, they produced them. They're bad. I debated Alon Werman. I won, but I'm still worried. And I'm worried for a couple of reasons. The first reason is that the Supreme Court has gotten things very wrong in the past, as recently as last week, in my opinion. I don't think that the court will uphold the executive order on the merits, but it has done more unreasonable things. I mean, I don't think we've really internalized as a nation just how little the 13th Amendment, the 14th Amendment, the 15th Amendment, the Reconstruction Amendments were actually effective in the United States for roughly a century. And we're kidding ourselves if we think that the court can't do that again. And I don't think that we're really prepared for that. We're not prepared for a Supreme Court decision that effectively guts one of the core promises of the 14th Amendment, in part because of a culture of judicial supremacy whereby what the Supreme Court says about the Constitution just is the Constitution in the minds of a lot of people. That's our default. And the second is that I genuinely think we're up against an administration that believes in a higher law than the Supreme Court and is utterly convinced that their understanding of that law is the only source of normative obligation. I think that anything that the administration does to comply with what the Supreme Court or any court says is pragmatic, based on the judgment that it's in its interest to do so. Its promises are worth only as much as the cost-benefit calculus that is operative when they make them. If the calculus changes, they'll change their position. I don't doubt for a moment that if this administration thought that they could get away with it politically, they would outright disobey a judgment of the courts, an order from the court, no matter how unambiguous. That they believe that Donald Trump represents a sovereign people who are the law higher than any constitutional text, although they don't actually think they need to make that choice because they believe the on-paper Article 2 president is practically and legally supreme, particularly when it comes to protecting the nation against alleged invaders, that he has the ability to designate as such. You know, I won't mince words about this. I think these people are fascists, and I mean something very specific about that. I mean that they adhere to an extreme, exclusionary, violent nationalism that's prepared to appeal to violent multitudes in order to enact its will. That they are the ideological descendants of the saboteurs of Reconstruction who would and did kill people and overthrow governments in the name of their understanding of the law. They maintain that the Reconstruction amendments were illegitimate, that the Constitution, in its original purity, was dedicated to white rule, and that couldn't be changed. They expelled and persecuted Black people, Chinese people, Jewish people, and their allies for decades. And you know what? Legally, they mostly won. What the Klan was able to accomplish through violence, the Supreme Court solidified and legitimated in Cruikshank, in the civil rights cases, misnamed though they are, in Plessy v. Ferguson. So you have this initial fascist violence that then is given the label of the law after conditions change on the ground such that, well, what else are you going to do but codify it since you can't do anything about it? This is something that the Supreme Court has done time and time again historically. It follows power. The law on the books in the United States reports quite often follows the law on the ground, and the law of the ground has been shaped by reactionary violence. Now, this is not to say that we have a fascist constitution or a constitution with any, essential characteristics normatively. It's characterized by profound contestation, our constitutional history is, rather than any unitary white supremacist domination or empowering understanding of the Constitution as a means of protecting civil equality and freedom. And the Reconstruction Amendments are proof of that. Guarantee of birthright citizenship being in the Constitution is proof of that the Constitution can be shaped in its text and history by marginalized and persecuted movements, because they can become powerful. But I'm worried because reactionary constitutionalism is deeply rooted in our nation's history and tradition, and it is in executive power. Farrah Peterson, in an article that I find myself returning to practically weekly at this point, called Our Constitutionalism of Force, talks about how the Capitol rioters, like Trump himself, asserted a set of legal claims. And she details how violent claims that have been ratified by elites or through community consensus have become part of the fabric of our formal law. Jared Goldstein has a fascinating article entitled The Klan's Constitution, which leave no doubt that even the most brutal episodes of racist violence in the nation's history have been committed in the name of the Constitution. Now, not all of them were successful in creating new orders that conform to their demands, but many of them were. And still others have produced effects which have lingered on long after the judicial decisions which legitimated them have been branded anti-canonical. So in Farah's account, to call the Capitol riot lawless disregard of the Constitution risks including a long history of reactionary constitutionalism that is currently in power and can win. So I think we need to be prepared for just about anything. And we need to be prepared to say, absolutely not. The Supreme Court cannot take birthright citizenship from people. I'm not going to do the Stringer Bell thing and take notes on what I'm confident that the administration would consider a conspiracy, but I will say that you can't do mass deportation without help from people who think that they're legally obliged to follow you. And we need to prepare people not to accept an obligation to carry out the administration's destruction of one of the best things that this country has ever produced. And I want to conclude by just pausing on how evil in a constitutional sense what the administration is doing actually is. Like, the citizenship clause isn't just part of the Constitution. It's a monument to the possibility of empowering constitutionalism in the United States, of genuine small r Republican constitutionalism in the United States. It's a monument to a world historically successful democratic struggle against domination, and it's a means of its continuance. It promises birthright citizenship to all who would otherwise be subjected to the arbitrary power of regulatory and enforcement mechanisms over which they have no say. But there's an exclusion in there for the children of citizens of native nations, of Indian tribes. Now, why? Now, the answer historically is because the same abolitionist movement that converged around birthright citizenship for the sake of Black freedom came to support tribal sovereignty as a means of securing native freedom. And supporting tribal sovereignty meant recognizing that tribal citizens living on tribal land were not generally subject to the criminal and civil laws of the United States, and declining to impose U.S. citizenship upon them. So the children of tribal citizens were originally excluded from birthright citizenship precisely because they were to be protected by their own sovereigns against domination, and the United States would respect that. Now, what do Trump's lawyers do with this exclusion for the children of tribal citizens? Well, they contend that because the children of tribal citizens aren't guaranteed birthright citizenship, well, neither are the children of undocumented immigrants and temporary visitors. And they argue that tribal citizens have supposedly greater allegiance, greater loyalty to the United States. Now, the notion that citizenship under the Citizenship Clause is based on loyalty is ridiculously ahistorical. But I just want to talk about how this argument basically inverts the purpose of the Citizenship Clause. In the hands of Trump's lawyers, a constitutional shield against settler colonial domination, the domination of an indigenous people by colonial power, becomes an unconstitutional sword that's wielded to dominate people who, unlike tribal citizens at the time that the 14th Amendment was ratified, cannot depend upon the protection of any competing sovereign against U.S. law. people who are born to undocumented immigrants or temporary visitors to the United States have to obey all the civil and criminal laws of the United States. There's no sovereign territory on which they are insulated from federal power. And unsurprisingly, the assertion in this brief that tribal citizens are constitutionally accepted from birthright citizenship has created confusion about whether the administration considers Native peoples to be United States citizens at all. And so I just want to say that nothing of what the Trump administration is doing is accidental. It may look sloppy, and in certain respects, it definitely is, but there's a strategy to it, and that's bad. We have an administration that is acting on a reactionary constitutionalism that resembles that of the antebellum period and the immediate post-war period, one in which unchecked power over racialized populations who are deemed unfit to govern themselves is a constitutional rule. These arguments, these constitutional arguments, have been heard for far too long. They should not be heard again.
Thank you so much, Evan. Thank you so much to everybody. We're running low on time, have to end soon. So I don't think there'll be time for questions for this panel. So I apologize for that. Having said that, we do have one more wonderful speaker, my former colleague, Jeremiah Chin, who is currently an assistant professor at the University of Washington. We'll give Jeremiah the last word, and then I'll close with a couple of remarks.
Thank you all for having me again. I'm thrilled to be here talking about this with you. I am not thrilled about this opinion or the implications, especially the wonderful job that the many other panelists on this webinar have been profiling. I want to actually take the incredible segue that Professor Bernick just gave me in terms of thinking about colonization and Indian law to think about how unsurprising maybe the current Trump administration and its defiance and judicial acquiescence to that order is if we look at the history of federal Indian law in the United States, where we've had a whiplash back and forth between judicial supremacy, executive power, and plenary power exercised by Congress based on the whims and constraints ordered by the Supreme Court based on uninformed, ahistorical, and disingenuous understandings that are primarily racially motivated at other peoples who are not white, aka white supremacy. The way that I think about it too is especially the historical discussion that came up earlier in our first panel reminded me of the historical discussion in various Indian law cases before the Supreme Court, whether that's Chief Justice John Marshall in the Cherokee Nation versus Georgia case determining that Indian tribes are independent or domestic dependent nations simply because they can't be foreign and they can't be part of the United States, but instead compares them as a guardian to the ward in a constant state of pupillage, which completely rewrites the history of recognition of the United States sovereignty based on the fact that indigenous tribes not only helped to form the system of government that the United States copy and pasted into parts of our Constitution, but also the fact that those indigenous nations were supportive of the United States in its assertion of sovereignty in defiance of the British. Then we also think about cases like United States versus Sandoval in 1913, whereby the United States Supreme Court recounted the Indian superintendent over the Pueblos in New Mexico, which he described as a ceremony. There was religious ceremonies that white people were excluded from. And so in his notes quoted by the Supreme Court, he said, "It is nothing more, I assume it is nothing more than a ribald debauchery," based on his interpretation of savagery of the Pueblo people when it is just a sacred ceremony that they hold that he was not allowed to attend. And so his exclusion suddenly became a default rule why superintendence over the Pueblos is not only mandatory, but necessitated. And the Supreme Court ends up deciding that the Pueblos are like indigenous nations, even though they're not on a reservation, and leads to codification and statutory law afterwards. The one that reminded me the most of, however, is a decision from the 1950s just decided right after Brown versus Board of Education in Teton versus United States, where the United States Supreme Court is deciding the status of Alaska Natives based on the fact that they are not within treaty regulations by most of the tribes within the United States and were in fact acquired later because their land was acquired from Russia. So how do we determine the status of these indigenous peoples who are very much like the indigenous peoples in the main continental United States, but are still different under a different set of laws? And the court in Teton leaned on this ahistorical assumption of how do we think about history in the line that I'll never forget, where the court says every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not sale, but the conqueror's will that deprived them of their land. The idea there being not only are we reinstantiating this ahistorical narrative of savagery that forces and reinforces colonization and white supremacy, but also it leans into the broader understanding of whose power are we focused on here, the will of the conqueror in Tehran, when it was really, even in Marshall's own view, by force or by treaty, and force had to be through some kind of just warfare underneath a colonial system, rather than just mere pure power. The Supreme Court, unfortunately, I think, in this opinion, has hitched its wagon of power rather than to the people or even the Constitution itself, but rather to the executive, and this executive of all executive branches, to hitch your power to. In terms of defining and refining, how do we think about the law? It has sacrificed lower courts and their opinions in the name of maintaining legitimacy in the eyes of this president, rather than maintaining legitimacy in the eyes of this nation. We see that in the ways this decision is signaled and reread to other people. We, I think, on this call have a very high level understanding of this opinion, because we not only understand the history and context, but we understand the law in a very detailed and specific way. People, when they were asking me about this opinion before the Supreme Court, they're asking how the court is going to rule on birthright citizenship. And then I get to be the law professor and explain to them, well, they're actually not legislating birthright citizenship. We're thinking about the Judiciary Act of 1789 and how that interacts with the universal injunction standard. Nobody understands what that means. They see Trump versus CASAs, and they see Trump wins. And that legitimizes his power, even though the court's opinion by its text is incredibly narrow in limiting the universal injunction under the Judiciary Act of 1789, leaving in major footnotes that Article 3 might comprehend a nationwide injunction, Congress might pass a law allowing nationwide injunctions, that there are other remedies available to us, not only under the Constitution, but also within the courts itself. So what this opinion signals and forebodes for the future, for me, is nothing short of an abdication of the court's own legitimacy by tying it to this executive branch in particular. I think now is the time, rather than for grief and disunity, but for collaboration. As Jessica's comments highlighted the human nature Professor Levin's comments highlighted the human nature of these rulings and litigation, that these have very serious effects on people, particularly people who do not or might not be able to understand the long and unhinged nature of our constitutional order, and how sometimes it takes abrupt turns and changes that people then have to redirect. And so I think it is our responsibility and role to help bring people into the fold and create coalitions that will not only bridge these ahistorical silencing of history, to reference Michel Rolfe Trujillo, and how which history the court tends to use. This genre of history and tradition originalism that the court has constructed, I think, was very well pointed to earlier, how they're kind of sacrificing the Reconstruction amendments in the sake of and the name of the original founding in the 1700s. The idea that somehow those founders are constraining things that we did again and had to redo because of a civil war. So my final thought is that this opinion, to me, has a very big Dred Scott energy, whereby the court is taking a straightforward but complicated and politically tenuous legal issue of personhood and citizenship and trying to duck it in favor of a procedural issue, and that the public does not quite understand. Dred Scott versus Sanford was really an initiated case about his freed papers and whether or not his status in a free area and working for pay and his residency would grant him his freedom for purposes in Missouri. The court ducked that issue by just redefining his citizenship and understanding of personhood, and thereafter we had the Civil War. Now we have the court addressed with a very clear, and I think unarguably clear, constitutional question that should be answered. Yes, the 14th Amendment guarantees birthright citizenship, full stop. And the court could have issued that one sentence and just walked away. But instead, the court ducks the substantive birthright citizenship issue in favor of the procedural question of the Judiciary Act of 1789, causing more confusion, misunderstanding, and tying its legitimacy to this executive branch in a way that I find thoroughly destructive to this Supreme Court's own legitimacy. So I know that I might not sound terribly optimistic in my comments. I promise I am. I think that there is a very important role and function for folks going forward through collaboration, but this opinion in and of itself is pretty terrible.
What a great valedictory line, right? Thank you, everybody. I want to do a round of thanks. Thanks to Karsten and Neil and Nicole and all of the staff who made sure that this could happen, to Dean Verona for sponsoring this event and doing the introduction. I want to thank the audience. When I read through the list of who's here, I see staff and faculty and students from Seattle U, faculty from across the country, alums and lawyers, members of the general public and members of the media. So lots of different people here. I hope we can provide something and have provided something of use to each of those different constituencies. And thanks to the group of wonderful scholars who joined us at a moment's notice, gave us their best, tried to explain these complicated issues in very simple terms and in ridiculously short time periods. So thank you to everybody. Very much enjoyed this event. Hope to see most of you on both sides of the podium next year. Thanks very much.
Thank you.
Thank you.